Let's talk about the knife. Several people have argued that the knife should have changed because the knife was a multi-tool knife and not just a regular knife. That should have changed the way that the verdict came back. Legally speaking, what are your thoughts on that fact?
Willie D. Live.
And you mentioned it, the team of attorneys he had. Man, Russell Wilson leading that thing, man. That's a bad boy. Mm-hmm. Russell Wilson, I hired Russell Wilson for me. Whenever I got held in contempt, he came and handled my business. So I'm talking about a brain, man. A brain. Like he gonna outsmart them folk over there. He gonna come at them in all different directions, and he gonna outsmart them folk, and he gonna do it in a very meek, astute, and just, calm. But he gonna be at their throat though. And then you got Justin Moore. He's a civil rights attorney. I know Justin Moore got a couple murders under his belt. Holla at Justin. Shout out Justin. And another thing about Russell, he tries cases and he does appeals. So you're not going to get too much past Russell. Like Russell knows how to look at that transcript for the trial and point out what's wrong and fix it. You know what I'm saying? So, I got a lot of faith in that team, and I'm very excited, man. I'm very excited about that.
Mm-hmm. Well, was this case more about the law, the facts, or the credibility of the witnesses?
I think it was more about the law. Well, if the appeal, let's speak positively. When the appeal is granted, it'll be about the law. I think right now the case is about the facts. I think that's why they got the result that they got, because they leaned too heavily in the facts and they didn't use as much of the law to their advantage. And you can't use the benefits of a self-defense claim without the defendant letting the jury inside his head, man. You just can't do that. It was almost like a pump fake or something, like a 3-day long pump fake. I mean, you set it up for him to testify and then he don't testify. And it's only two reasons. Either you didn't prep him or he was scared shitless. But proper preparation prevents piss poor performance. You see what I'm saying? So if you would have been prepping him, I mean, what was that, a year ago? This case been pending for a year? You could have prepped him every Sunday. That's 50 times. You could have prepped him every Monday. You see what I'm saying? I mean, and another thing, it's no excuse for it, man, because I've had my client, when we won the murder trial, he was inside. He was in custody. Karmelo was out. Man, y'all could have Sunday dinner by the pool and go over your questions. You see what I'm saying? So it's just no excuse for it, man. And like I say, I'm not the attorney police. I'm not the ineffective assistance of counsel police. That's similar to snitching to me. You know what I'm saying? Like, so I kind of do this, but I'm just telling you what I would have did. I got a reputation of, we 17 and 1 of murder cases, baby. I don't really talk to the other side. You know what I'm saying? But I'm just telling you what I would have done if it were me.
Yeah.
But I'm sorry, let me say this. Yeah. If ineffective assistance of counsel is the only way to get that man home, though, do it. I'm for it. If that's the only way, let's do it. Because that boy needs to come home.
That's right. How much impact do you think that newly released footage of the incident had on the jury, if the jury would have been able to watch that video footage over and over and over again at home?
You saying like it's a bad thing that they could watch that outside of court? Is that what you're saying?
I'm not saying it's bad or it's good. I'm just asking you. I'm asking you, what do you think about it? What are your thoughts?
I think it confuses things, man. What I think was wrong and what I think the defense should have tried to find a way to do, because what I heard happen, you can't really see the figures on the video all the way. You can see the scrapping, you can see the commotion, you can see the movement, which is all vital to his defense, right? But I'm hearing that they let somebody get up there and explain who is who. I'm against that. I'm against that because there's too many factors.
They can't. They wouldn't be able to do that. If I was there myself, I couldn't have told you where I was. Because it's too grainy, it's too blurred. everything is black. All of the people and their bodies are black. So you can't see
Yeah,
what's what. Unless I had
yeah,
a full puffed out afro and I could say, well, that's got to be me right there. Because
right,
the big puffed out afro.
right. And you got to understand, you know, in these cases I do, man. I mean, there's like, I mean, maybe on average, 400 pieces of evidence. I delve deeply into each piece, man. So that one piece of evidence, that's some old confusing stuff that they doing over there to me. But why you releasing it now? First of all, you see what I'm saying? Didn't they release it on Juneteenth or something? Something crazy like that?
I think they did. I think
Yeah,
it did
yeah,
on Juneteenth.
yeah. But I mean, I think it's just confused because you have to look at all the evidence together. See, you got to understand, people are just looking. There's many ways to a win. People are just looking if it was self-defense or not. Well, no, you need to be able to look at all the evidence and see, because what's for certain in this case is the time didn't match the crime. The time didn't match the act. You see what I'm saying? Now, a lot of circumstances surround that because he didn't testify. You see what I'm saying? So the jury can't say they knew what he was thinking. But, you know, all of the evidence in its totality is important because not only are you trying to get somebody off, get them a not guilty, you're also trying to get them as least amount of time as possible. You see what I'm saying? So it could be something on that video that they could have used, you know, to mitigate some evidence. But I heard them, you know, that's another thing I heard wasn't much of an effort on the mitigating evidence in the punishment phase,
Yeah.
which is a big problem, man. That's a big deal. It's a big deal.
Let's talk about the knife. Several people have argued that the knife should have changed because the knife was a multi-tool knife and not just a regular knife. That should have changed the way that the verdict came back. Legally speaking, what are your thoughts on that fact?
I don't, legally speaking, I'm glad you prefaced the question with that because a lot of people ain't gonna be happy with my answer. If I don't think that matters. If it was a pencil and it was used to kill, it would be you see what I'm saying? It would qualify as a murder weapon. If it was a highlighter and it was used to kill, you got a deadly weapon finding where the jury gets to decide if the weapon was used in a manner to cause, you know, death. And, you know, no matter what it is, I mean, if it got the blood of, you know, Austin Metcalf on it, you know, it's the murder weapon.
So even if it was legal under Texas law, you're saying that shouldn't change anything?
Well, what I'm saying is I think that was a collateral issue. I don't think there's anything that swayed that gave the jury the ability to check the not guilty box. I think that's a collateral issue the state used to kind of make the jury madder at him. Oh, he has a knife on the school campus. That's what DAs do. They play on their emotions. So even though, you know, his self-defense claim has nothing to do with if he should have added the knife in the first place, that don't really matter. The self-defense is if he thought that he was about to experience serious bodily injury or death. You see what I'm saying? And he used, you know, deadly force to defend himself. It don't matter if he should have had the knife or shouldn't have. That's just some extra stuff they threw in there to make them white folks mad. And I'm telling you, in Collin County, what the DA gonna do, it never fails. He came to your community. He's doing this where your kids are going to school. Your kids are supposed to be safe. You know, they playing that whole card. So even though that's not in the black letter of the law, that is a method they use to try to get the jury on their side and to dislike the defendant. You see? Yeah.
But I can understand why they would do that. I mean, everybody trying to win, right? So I can understand.
You're right.
To be honest, if I was on that side, I'd do the same thing. You know, my thing is to discredit the other side as much as I can. So I absolutely understand that. But if you were preparing Karmelo Anthony's appeal today, you know, what would be the main issue that you would bring up to try to get that appeal granted?
Well, let's be very clear. I'm not an appeals attorney, but I do know how appeals work. And right now, I think this would be the part where we're getting the investigation done. We might be trying to track the jurors down and interview them. We would definitely be looking at I know that they're looking at the record right now to see what all of the appealable issues are. Again, error has to be preserved by the trial attorney, meaning he has to object in order for those issues to be appealable. They're probably looking at that stuff. The main thing that I've seen and had different conversations with people, in the attorney community is the jury charge. The judge put some language in there that wasn't the law. That spoke about provocation. That basically made it seem like, I can't say what the exact language is, but attorneys that see this will know exactly what I'm talking about, and probably everybody else. But it was a paragraph that says something like, almost was turning Karmelo into the aggressor. Like, if you believe that he was the aggressor in this case, blah blah blah, and that's the jury charge is it's a packet, and it has all the law that the jury is supposed to depend on in it. The judge reads it to them before they deliberate. It's a very big deal. So my point is, if it ain't in the jury charge, you can't depend on it. And if it is in the jury charge, it has to be law. It has to be good law. So if you put bad law in the jury charge and the jury used that to render their verdict, sounds like an appealable issue.
Yeah, and don't the jury rely heavily on instructions from the judge? So if the judge say, "Hey, you need to be thinking this way. I'm gonna send you back here, and I need you to come back out and look. Y'all need to come up with a decision right now, today." That would be overstepping his boundaries. But I've heard of judges being able to do stuff like that. And doesn't the jury rely heavily on the instructions from the judge?
Are you talking about when the judge was like, "I'm gonna put y'all in a hotel tonight if y'all don't have a verdict"?
Oh,
I think that was improper, man. I think that was improper because you are basically rushing them to a decision. It might be a jury here that's ready to go home. It might be a jury here that want to go home to his babies tonight. He ain't trying to go to no hotel. Damn what the judge talking about. I ain't trying to do that, judge. So I'm finna go and check this box right here. I was strong on not guilty, but it's cool, y'all. Let's go ahead and do guilty and get up out. See, those are the kind of things that entice a jury to go outside the bounds of what their duty is. That's why you don't say that. You say to them, "Hey, y'all get this done as quickly as possible. Any questions y'all have, y'all send back to the bench, and we'll get both sides in here and we'll go over them." But telling them what you gonna do if they don't render a decision quick enough, how can you not think that didn't affect that decision? I mean, that's they supposed to feel like they got all day. They got forever in a day to as long as it's the correct verdict and they render it the right way. They not supposed to feel like it's a shot clock. When the shot clock on 5, you look to shoot the ball. That's as simple as that. So
yeah, and it could be also a situation where a juror may think that if he doesn't follow the directions of the judge, that somehow he might find himself in hot water with the courts. So
yeah,
there's a lot of jurors who show up for jury duty. They're not really acclimated to jury duty. They don't really know how the process goes. And so they're counting on the prosecution and they're counting on the judge, who, by the way, gets this check from the same people.
By the way.
To give them proper instructions legally. You know what I'm saying?